Okay, so the question that I'm dealing with here is a question sent in which reads, the direct application of the right to equal treatment and discrimination laws to many kinds of contractual relations provides a good model for how human rights law might be made directly horizontally applicable to particular classes of private parties to contracts such as employers. Discuss. And so the question raised is, well, how might I plan out an answer to that? So I think the first thing I'd want to do is to consider, well, the quotation that we're discussing, what's the proposal being made in it? It appears to be a proposal that what happens in the Equality Act, direct application of the right to equal treatment and discrimination laws to many kinds of contractual relations, that what happens there is a good model for how human rights law could be made more generally, directly, horizontally applicable to particular classes of private parties to contracts, such as employers. So we're looking at a role for human rights within people who are parties to contracts, and the suggestion appears to be that the model that we're looking at is a model following the Equalities Act, where you apply human rights to only a restricted range of parties. We see in the Equality Act that it applies to employers, it applies to those that are offering services and goods and the like to the public. And it's a one-sided application, that it's only the employer that's subject to the obligation not to discriminate, not the employee. It's only the person who offers the services to the public that's subject to the obligation not to discriminate. So it's a model that applies to a restricted range of contracting parties. It's one-sided, but moreover, we might say it's a model which has as a distinct feature that the balancing, such as was necessary, has been performed largely by the legislature. So the legislature has created a straightforward restriction on direct discrimination, subject to some possibility for reading down by the courts. But it's a model that effectively relies on the fact that there's no rational reason to discriminate, and as a result, there's not much balancing to be done in most cases. So is that an appropriate model for say, introducing directly applicable privacy, freedom to manifest religion, free expression, vis-a-vis private contractual parties? So creating a situation where employers would have to respect the privacy of their employees, their freedom to manifest their religious beliefs, their rights to express themselves. Well, what can we say about that? That we're meant to be discussing that proposal that we've now elaborated. Well, obviously, one of the questions is about the suitability of the range. If we are going to protect these fundamental rights horizontally, would we want to do so only with regard to those that make the types of contracts that the Equality Act bites on? I guess that there's kind of two distinctions that we could, or 2 points we could pick up. That one would be that we might think that behind the Equality Act was a desire to allow access to a market so that people could access jobs and goods and housing and the like. That in terms of protecting privacy rights within contractual relationships and we might think we're not going to be able to rely on the same access to a market type arguments, that it appears to be more a concern about redressing power potentially within the employment relationship, or within whatever contract we're concerned with. If that's the case, then we might wonder whether you wanted the same list of contracts. That if you're looking for contracts where there's a power imbalance problem, as opposed to people being irrationally denied access to the market problem, we might come up with a slightly different list of contracts. That it's difficult to immediately imagine what contracts might have such a power imbalance in, but I guess perhaps contracts, say between parties who are entering into an intimate relationship, if a contract was made between them as to what was to occur if the relationship broke up. You're never to publish anything about this relationship if it breaks up, and before we go on the first date, you must sign this contract. That perhaps contracts between those who are involved in a family company, that you can have these shares, or I'll make this money available to you, but only if, and the opportunities for, in a sense, inappropriate exploitation of power might not be restricted to the relationships that are bitten on in the Equality Act setting. The issue about balancing, that of course, the notion that the Equality Act assumes that there's no good reason why you would wish to not employ the best qualified person, and so there's no real need for balancing. By contrast, we might think that there are often reasons why the employer would wish to restrict the free expression of the employees, or would wish to restrict the privacy interests of the employees. That the problem tends to be a different one, that the power imbalance gives the employer an opportunity to over-restrict, to go too far. That then means that there's a different sort of problem, that there's a kind of problem of rather than banning this altogether, we have to determine whether it's gone too far. If we think of cases like the UIDA case, that the issue is, well, are there good reasons for banning the wearing of the religious necklace? There are in the cases of the nurse, but not in the case of the person working, checking people in at the airport. And so there's a slightly different need for a balancing process, which means that, again, that the actual model of the Equality Act, where basically the legislation lays down a straight prohibition, is not going to be appropriate. It's going to be need far more nuanced regulations. Perhaps Barbalescu provides another example here that we remember from Barbalescu. That's the employer monitoring the employee's privacy. The European Court of Human Rights comes up with a model for what the balancing process should consider, and says, well, the balancing process should consider issues such as whether there was advance notification of the possibility of the monitoring, the extent and degree of the monitoring, in particular, whether the monitoring included intrusion into the content or just monitoring the flow, that the reasons for the monitoring, especially if it went so far as monitoring content, whether there were less intrusive means available for the employer to satisfy the employer's wishes, and the consequences, or the consequences for the monitored employee, and the safeguards available to the employee. And so we can see that the factors that are coming in are much more complicated than a simple prohibition on the practice. That we might then bring in this further concern that the Equality Act works in particular in the context of whether a contract is available. That of course it may come in at a later position too, from promotions and the like, but whether the person's going to get the job to begin with, whether they're going to have the opportunity to rent the house. The regulation with regard to the broader range of fundamental rights, we might think raises the more difficult question of a kind of ongoing relationship, and of course that relationship has been entered on the basis of particular terms, and so we have the extra dimension that the person who is now seeking to rely on their horizontal applicable Article 8 right or Article 10 right or the like may well have signed a contract saying, I will not express myself in the following ways, or I'm fine for you to monitor all my communications. That of course the terms of that deal might have to have some role in the balancing process, again making the situation more complicated. This raises the question, if we are going to have horizontally applicable rights in the contractual sphere, whether an alternative model might be better. That one model, of course, would be to look at the quality of the consent. Was the employee aware what they were signing up to? And so far as they were, and genuinely agreed to it, that we might think that they were sufficiently protected. Now, we might reject that, but at least it offers the suggestion of an alternative model for the horizontal applicability of these rights, checking on whether it was an informed and real consent. Rather than the Equality Act model, which is more prohibitory. So what have we got left? That we've been considering whether it's an appropriate model from the perspective of whether we'd want to limit the horizontal applicability to the same range of contracts, that whether it would raise different sorts of challenges with regard to balancing, and I suppose that the third part of the model that we haven't discussed yet is the one-sidedness, that the fact that the Equalities Act only applies to prevent the employer from behaving in a particular way and not the employee. And there, I think we've also got a difficult question, that whether it should be the case that we'd only be interested in restricting employers from limiting the free expression of employees, and not the other way around, also wanting to limit employees from restricting the free expression rights of the employer. Because of course, as we've seen in cases like say CRISP and Apple, that often the argument that the employer is putting forward is that the employee's statements, expressions are attributed to the employer, and so the employer is putting forward an interest in a sense restricting the employee's expression because the employee's expressions might be attributed to the employer in some way. That perhaps means that we shouldn't be considering these cases in a wholly unidirectional way, only thinking about the tolerability of the employer's restrictions on the employee, but perhaps also should be thinking about the tolerability of leaving the employee with freedom to make expressions that limit the employer's freedom to be free from such expressions being attributed to them. And there might be other rights as well, where the employer potentially has an interest putting forward that they don't want the employees to be able to unjustifiably limit. I guess together that means that we could discuss whether it was a separate, a suitable model, but the answer that we might come up with is along the lines of, well, not obviously, that there are various distinctions in the two contexts that might mean that we didn't want to unthinkingly import the same model. I hope that's of some help.